Hello friends. Today we are going to discuss about emergency treatment of persons with mental illness. I am Dr. Suresh Badadmat, Professor of Psychiatry working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. If you want to have a legal opinion, please do contact an advocate. This presentation is not a substitute for professional legal opinion. Conflict of interest? None. In this video, I am going to discuss about emergency treatment of a person with mental illness under Section 94 of Mental Health Care Act. The target audience who are going to benefit by watching this video are doctors, psychiatrists, mental health professionals such as clinical psychologist, psychiatric social worker, and psychiatric nurses. Along with this, persons with mental illness, family members of persons with mental illness, mental health review board members, central or state mental health authority members, and advocates. Let's discuss about the emergency treatment under Mental Health Care Act of 2017, Section 94. Mental Health Care Act of 2017 received the President's assent on 7th April 2017. Emergency treatment under Section 94 is very clear. It clearly says any medical treatment, including treatment of mental illness, may be provided for 72 hours only by any registered medical practitioner to a person with mental illness. That means he can provide emergency treatment either in the mental health establishment or in the community. Community means either in the camp, either at the home, or else even on the road, or even in an ambulance. So any place under the jurisdiction of India, the registered medical practitioner can give treatment up to a period of 72 hours. There is no requirement of a registration of such places. That means emergency treatment can be provided anywhere in the community. That's what the essence of this emergency treatment under Section 94. But however, before the doctor gives emergency treatment, he needs to seek consent from the nominated representative if he is available. If he is not available, go ahead and treat the person with mental illness. And however, please do remember, during emergency treatment, advance directive cannot be applied because it's an emergency situation. You cannot go in search for advance directive. Along with that, electroconvulsive therapy cannot be considered as an emergency treatment. It has been prohibited very clearly under this legislation. Further, we need to know what is emergency treatment. That is emergency condition. That is a death or a irreversible harm to the health of the person. That is one. Or the person inflicting serious harm to himself or others. So that is the second important. That means dangerous to self or others. And the third, the person causing serious damage to the property belonging to himself or to others, where such behavior is believed to flow directly from the person's mental illness. That means either dangerous to self or others, or else is destructive to the properties of his own or others, should directly be related to the person's mental illness. Then only the emergency treatment clause can be evoked, and that can be used for a period of 72 hours by a doctor to treat anywhere in the community. And emergency treatment includes transportation of the person with mental illness from the community in an ambulance to a mental health establishment, including the assessment in the mental health establishment will be considered under emergency treatment. And please do remember, my dear friends, no RMP or psychiatrist shall give no non-emergency treatment. That means you will not give any non-emergency treatment under Section 94. Like ECT is not considered as an emergency treatment here. You cannot give that. Hence, that has been prohibited. Emergency treatment, Section 94, Subsection 4 clearly says that emergency treatment referred to this section shall be limited to 72 hours or till the person with the mental illness has been assessed at a mental health establishment, whichever is earlier. To explain this, my dear friend, if a person with mental illness is been brought to the hospital within 24 hours and in the emergency he has been assessed and a diagnosis is made and he is admitted, then emergency treatment is less than 72 hours. That means The assessment is over means the emergency treatment clause can be evoked here. That is what this means here. To conclude, my dear friend, emergency treatment does not mean admission. It is keeping the person or treating the person in a community for benefiting the person with mental illness. Use this clause to protect the person with mental illness who is acutely agitated or severely psychotic in the community so that his rights are not violated or he does not violate the rights of the others. Thank you very much for giving your valuable time. Stay safe.